Shy, thank you for coming today.
Thank you.
On behalf of Cebrap, I'd like to thank you. You have 40 minutes, and you get 30 minutes, I worry you, okay?
Sure.
Thank you so much.
Okay, great. Well, thank you for inviting me. And I'm really happy to be in Brazil. I've been here once before, and Cebrap had invited me last time, and this time the law school here invited me. And both times I think I've had such a wonderful time, and it's just also been really intellectually very interesting for me because I've been getting very good questions on the papers that I've presented. So I'm hoping, and I'm sure I will get a lot of really interesting questions today. So yeah. So this is a paper that I've written with 3 others, but the other 3 looked at 3 other countries, which was Pakistan, Malaysia, and Sri Lanka, and I looked at India. But so I'm sort of going to be presenting the Indian part of the paper. So let me begin. And I will try and speak slowly, but in case you have problems understanding me, please stop me and I will explain again. All right. So the rule of law, the logic goes, acts as a force of moderation and in matters of religion serves as a key tool for resolving disputes. So, and for years, this way of thinking about the relationship between religious strife, law, and legal processes has influenced conversations among scholars, human rights activists, and policymakers. This way of thinking sees law as an antidote to religious tensions, which means that law moderates rather than fuels religious problems. One does not have to go far to find examples of this paradigm. In December 2013 speech to the United Nations General Assembly, the Special Rapporteur on Freedom of Religion or of Belief, Heiner Bielefeld, celebrated the power of law to help resolve chronic patterns of religious violence and hatred. He insisted that, and I quote, an open constitutional framework that allows free manifestations of existing or emerging religious pluralism on the basis of equal respect for all is a sine qua non of any policy directed towards eliminating collective religious hatred by building trust through public institutions. According to Bielefeld, institutions of law, above all constitutions and the courts that interpret them, serve as bulwarks against religious strife, polarization, and hatred. Constitutional law, he insists, is central to resolving conflicts among religious groups. Bielefeld's perspective finds considerable support in academic writing on constitutional law and human rights. One influential example of this can be seen in Ran Herschel's very important book. It's called Constitutional Theocracy, in which he writes that constitutional courts work to contain, constrain, and streamline religious interests and impulses in public life, such that constitutional law and courts in virtually all such polities have become bastions of relative secularism, pragmatism, and moderation. A similar argument has been made in the arena of ethnic conflict, where incorporating incentives that encourage moderation, cooperation, and accommodation in legal and institutional arrangements, including the constitutional design and amendments, the political system, and electoral processes, is expected to contain, limit, channel, or manage conflict. But does law really moderate or diffuse tensions? The understanding of law as a salve for religious strife belies the escalation of religious tensions that often accompanies the judicialization of religious disputes. Rather than serving as a mechanism to soften religious boundaries and harmonize religious interests, legal processes and institutions, particularly courts, in certain cases, have actually produced a hardening of boundaries and a sharpening of antagonisms among religious communities. Law itself has participated in the intensifying of religious conflict. So in this talk, I will examine how and why law exacerbates religious conflict. My goal is not to argue that law and legal action always exacerbate religious conflict. I do not believe that to be the case. My goal is more modest. I look closely at the unintended consequences of legalizing religious conflicts and call attention to certain ways in which legal action might deepen and sharpen the very conflicts over religion it purports to resolve. In particular, I wish to highlight a specific mechanism, the strategic use of legal language in court judgments by political and socio-economic groups in India. I will focus on the issue of religious conversion and its intrinsic connection with Hindu religion in India. I will show how constitutional law and judgments on religious conversions have shown a tilt towards one religion and put barriers to conversion out of that religion. I will also show how these judgments have provided opportunities for socio-religious groups, particularly the Hindu right, to polarize public discourse and deepen discord among India's religious communities. So now I begin. Am I clear? Is it more slower? All right. Okay. So let me begin. Let me very quickly give you my argument so that you can. So what I'm arguing over here is that the way in which the Constitution defines who accesses affirmative action makes the courts rule in a particular way, and it actually biases the court's judgments, and that then is used by political parties and social movements to polarize the public spaces. So that's in short my argument, and I'm going to show the connection between how religious conversion, Hindu religion, and affirmative action are linked, and how the courts then have to interpret affirmative action in a particular way that then leads to more polarization. So law is actually polarizing in this effect. Okay. So let's go back to 1978 when there was a Christian missionary named Reverend Stanislaus. He challenged, there was an act which was passed which is called the Freedom of Religion Act, and this was passed in a region called Madhya Pradesh, one of our regional states. The act prohibited conversion by force, fraud or inducement and prescribed 1 year's imprisonment and a fine for those convicted. Stanislaus objected to the act.
From one religion to another.
Yeah. So basically they said you cannot have force, fraud, while you're converting, so or inducement, but they don't define what force, fraud, or inducement are. It just basically says anybody. So Stanislaus objected precisely to this aspect. He said that the definition of inducement was very broad, and what is termed as inducement. In a sense, you can't convert anybody because it could be challenged and. The courts could say, oh, this was inducement and therefore you can't convert. And the problem here is that in Hindu religion, there is no proselytization. You're born into the religion. There is no way to enter the religion. There is no conversion. So, whereas Christianity and Islam are proselytizing religions. So, the big issue in India has been that when you have a Hindu majority, which is about 80, now it's about 82, 83%, you have a Muslim minority of about 12%, and Christians are about 2 or 3%. And the big issue is that when you have a very hierarchical caste structure within Hindu religion, and this hierarchical caste structure means that you have Brahmins at the top, who are the priests, followed by the warriors or kings, followed by the traders, and then you have the farmers. And right at the bottom, there are these people who are called they're called untouchables in a very derogatory way, but they have been legally classified as scheduled castes, and they're about 12 to 14% of the population. And then you also have scheduled tribes, who are the indigenous people, who are about 12% of the population. So the big issue within Hindu religion is about the scheduled castes, because a lot of scheduled castes convert to Islam or Christianity in order to get dignity, because they have no dignity within Hindu religion. So they convert to these other religions. But there is a big movement within especially among the Hindu right, who really do not want these groups to convert out of Hinduism, but they cannot promise them anything within Hinduism, because all they can promise them is this sort of ill treatment. So, and affirmative action is connected to these two groups: the scheduled castes, who are within Hindu religion, and scheduled tribes, who are not within Hindu religion. They're indigenous groups, right? So, okay. So, so when Stanislaus went and challenged this to the act, he lost the case in the lower court. Then he appealed to the Supreme Court. He lost the case again. And the Chief Justice, writing for the court, insisted that there was no fundamental right to convert another person to one's own religion, because such a right would impinge on the freedom of conscience guaranteed to all citizens of India. The court was referring to the article in the Constitution that guaranteed religious freedom to all groups. That's a fundamental right. So India is not a Hindu state. It promises secularism. Now, the Hindu right interpreted this judgment as a victory for Hindus vis-a-vis Christian missionaries, and they introduced a new federal freedom of religion bill in the Indian Parliament. That didn't pass, but it did stimulate the introduction of several such anti-conversion bills in several regional states. This Stanislaus verdict and its aftermath pose two questions for us. Is the Supreme Court of India biased towards Hindus and against the proselytizing religions of Islam and Christianity? And B, the second question is, even if it is, what explains the way in which the judgment was politicized by the Hindu right? The answers challenge the conventional wisdom on the moderating force of law. Conversion-related cases in India's higher judiciary show a very clear tilt towards limiting conversion activities. This is not because Indian judges have a pro-Hindu bias. This is because they have a commitment to social justice and reform, and that echoes the position of the Indian Constitution. Let me explain. Who converts in India? As I just mentioned, they usually occur amongst these scheduled castes within the Hindu caste system, and scheduled tribes, who are these indigenous groups. They want to improve their low social standing. They convert to Islam or Christianity, which promise equality to their congregants. They also convert to Buddhism. But Buddhism, interestingly, has been treated differently both by the Hindu right and other groups, and also by the courts, and also by the state, because Buddhism is seen as an indigenous religion, as connected to Hinduism, whereas Islam and Christianity are not seen as that. They're seen as foreign religions. Now, the scheduled castes are about, as I said, they're about 17% of the population. And even today in rural India, these people all live in separate groups within the village. They have to live in separate enclaves, and they're not allowed to use the wells or enter temples of the upper castes. Even though legally untouchability is banned, they suffer a lot of social discrimination. Now, those who drafted India's constitution had a foundational commitment to social justice for these groups. So the constitution says that only scheduled castes and scheduled tribes will get affirmative action benefits in three things: government jobs, political constituencies, and educational institutions. Political constituencies, which means that there is government jobs, political constituencies, and
political.
Yeah, so which means that there is a reservation for, if you want to contest elections, there are certain places where only scheduled castes or scheduled tribes will be allowed to contest elections. So that you have political representation. There is affirmative action reserved for a scheduled caste or a scheduled tribe. And that sort of rotates in these constituencies. So it goes from one to the other. So then only people who are a scheduled caste or scheduled tribe can contest elections, then no other caste can. Okay, so now the legal definition of a scheduled caste was a Hindu. That's what the constitution says. It specifies that if you are a scheduled caste, you have to be a Hindu, because scheduled castes are within the Hindu caste structure, and this limits the range of beneficiaries of disadvantaged groups to those within Hinduism. This decision has meant that the constitution and the laws that are created out of it inadvertently install barriers to conversion out of Hinduism. Because the minute you convert out of Hinduism, you're no longer a Hindu, you become a Muslim. Then even if you are a scheduled caste who has converted, you're now a Muslim, and therefore you cannot access this affirmative action. I looked at 80 religious conversion cases in India in the High Court and the Supreme Court from 1950 to 2006. These cases dealt with personal law, affirmative action benefits, and propagation. Propagation is proselytization. The issues actually pertain to reconversions to Hinduism, conversions to Islam, and to Christianity. So let me just give you briefly the findings that I had, the patterns of the court judgment. Over 50% of the cases dealing with affirmative action, in over half the cases, scheduled caste converts to Islam and Christianity were divested of their welfare benefits, which means that they were stripped of their benefits, they could not access the benefits. But even though several judgments recognize that even after conversion, caste sticks to the converts. So you have Christian converts to Christianity, and they're still considered scheduled castes by the Christian community. So people will not marry those who convert, which is what it means by saying caste sticks even though you convert to these other religions. And on reconversion to Hinduism, the court, on grounds that affirmative action is a group right, allowed the scheduled caste person to regain the welfare privileges as long as he or she could prove that the caste had accepted them into the fold. So that's what they had to prove. They had to, because there is no reconversion into Hinduism, right? Because you're born into it. But if the scheduled caste convert could say that I converted to Islam, but now I want to reconvert back to Hinduism, and my caste, which is a scheduled caste, is accepting me back, either through some caste leader who says, yes, we accept him back, or some form, then it's fine. Then the court says, yeah, okay, you're back, you're scheduled caste again. I ran a probability analysis on these cases, and I actually found that the converts to Christianity were less likely to win affirmative action cases as compared to converts to Islam or Buddhism. And the court's attitude towards, what's interesting is that the court has a different attitude towards scheduled tribes, who are the indigenous people, and scheduled castes who belong to the Hindu religion. Now, scheduled castes, they say that if you convert out of Hinduism, you're not going to access the benefits. But for scheduled tribes, they say that you can get the benefits even if you convert to Christianity or Islam, because the grounds are that a member of a tribe, despite his change in the religion, may remain a member of the tribe if he continues to follow the tribal traits and customs. So scheduled tribes indigenous people are treated differently as compared to scheduled castes. So the higher judiciary has actually tilted towards facilitating conversion to Hinduism, reconversion to Hinduism, and obstructing conversion away from Hinduism in affirmative action cases. And one can see that in the Indian Constitution and its interpreters, the judiciary, in their pursuit of one legal goal, which is social justice, have undermined another legal goal, which is religious freedom. Because in India, we have the Constitution is both transformative, but at the same, which means social transformation and social justice for these discriminated groups. But on the other hand, because India was created out of, after it was a colony of the British, it was partitioned into India and Pakistan was for the Muslims, and India was supposed to be for the Hindus, and there was a very, very violent partition. So when partition occurred in 1947, there was a 12% Muslim population that remained in India, and therefore the Indian state decided they would not be a Hindu state, they would be a secular state, and they had to make these the 12% Muslims and the Christians who remained feel at home. So the religious freedom therefore was a fundamental right in the Indian Constitution, but social transformation is also a fundamental right in terms of affirmative action. So they're twin goals, but in this particular case, the pursuit of social justice has led to the diminution of undermined religious freedom. Now, even if the court tilts this way, it is not necessarily polarizing. I mean, it can come out with these judgments, it doesn't really matter. What actually creates the polarization is how the political parties and social groups have used these judgments. The judgments have provided ammunition to advocates of the majoritarian Hindu politics and influential members of the minority religions to further polarize religious and public spaces. In the Stanislav's case, as I mentioned earlier, we saw how the Hindu right used the judgment to try and pass a bill in parliament banning conversion, because they tried to pass the bill but it didn't pass. Why does the Hindu right oppose proselytization? Their guiding ideology is known as Hindutva or Hinduness. And this was defined by Savarkar, who was one of their leading ideologues in the 1920s. And this was defined as, and I quote, as embracing all departments of thought and activity of the whole being of our Hindu race, close quotes. For Savarkar, he was an atheist. He didn't believe in religion, by the way. Hindus were a race who by definition followed a particular religion. So it was like being Jewish. So he equated being Hindu with being, it's both like racial identity, and even within Judaism, conversion is a huge issue. I mean, yes, you do have conversion, but the ultra-Orthodox, it's much, much harder to sort of, they don't accept a lot of converts, and in order to convert, it's extremely, extremely difficult, especially if you want to become an ultra-Orthodox Jew. So in that sense, he took some of that and sort of equated Hindus as a race who follow a particular religion. So Hindutva was actually a means for promoting the superiority of the Hindu race. And for them, they think that the exodus of Hindus to other religions would be very dangerous, and I quote, dangerous to the security of the nation and of the country. So the way in which the courts have ruled on conversion is music to the ears of the Hindu right. In their view, they've seen the court as trying to, and I quote, minimize the harmful impact of the Constitution. By the harmful impact, the fact that the Constitution allows religious freedom is very harmful if it allows this sort of conversion. And they also, and I quote, balance, and they see the court as having balanced the needs of the predominantly Hindu society by handing down judgments against conversion, and continue the quote, and by upholding Hinduism or Hindutva, and now they're equating Hindutva with Hinduism, as part of the national character rather than confining it to a religion on par with Islam and Christianity. So what those in the Hindu right want is they want Hindutva and to be equated with Hinduism, and they want Hinduism not to be seen as a religion, but to be seen as something much more than that. So Islam and Christianity can be religions, but Hinduism equals Hindutva, which is more than a religion, and it is supposed to be more a racial characteristic. So that's the way they perceive this. So any conversion out of Hinduism is considered a conversion out of the Hindu race, which then leads to a lot of problems for them in terms of how they see the security of the Hindu nation. So it's a very, their ideology therefore sees religion, it's not religion, it's much more than that. So it's also therefore unsurprising that in December 2014, the members of the Hindu right led a mass conversion drive in which 350 Muslims in a city were returned home to Hinduism. This sparked an explosive debate in Parliament and a walkout by the opposition, who called on the government to protect the constitutional rights of religious minorities. What this episode shows is an escalation of proselytization by the Hindu right, which is ironical since you can't really enter Hinduism except through birth. And it's also aimed at compelling Christian and Muslim groups to demand the state's intervention and perhaps even an anti-conversion law. So it's very bizarre because now the Hindu right has started having these reconversions back, and this has been going on not just recently, it's been going on over the last whole of the 20th century.
Reconversion they support?
So the Hindu right is now saying those who are converting out of Hinduism to Islam or Christianity, which are these scheduled castes and scheduled tribes, we are returning them back to the Hindu religion, and we will reconvert them back. So they're having these mass reconversion drives to get them back into Hinduism. So anyway, and that's creating a lot of problems between Hindus and Muslims and Christians in terms of both the religious lobby and as well as politics. India's courts have given Hindu nationalists new ways to express and legitimize their long-standing opposition to conversion in the language of religious freedom and judicial precedents. Part of the blame also lies with the ambiguity in the Indian constitution, in particular its difficulty in classifying Hinduism, which the constitution framers variously viewed as a religion, as a culture, and as a way of life. So they don't actually define Hinduism. It's been very, very hard, both within the constitution and later by the courts, to define what Hinduism is, because the courts have said Hinduism is a religion, but they've also said it's a way of life, and they've also said it's a culture. And this was most notably highlighted in a set of judgments on the Hindu rights use of Hindutva in election speeches, because in India you cannot use religious rhetoric in elections, it's banned. So when the BJP is the party in power right now, they used Hindutva in their election speeches, and it was taken to court, and the court ruled that Hindutva is not Hinduism, it's not a religious rhetoric, so it can be used. So, but in another case, they actually ruled Hindutva was religious rhetoric. So the court has been very, very, it's sort of flip-flopped. And the Hindu right took the judgment where the court said it's not religious rhetoric, and said, the judiciary has now given us the legitimacy to use Hindutva in the public speech, in the political and public arenas. The complex story of conversion laws in India shows how the language of religious freedom and the authority of the courts can work to further fuel religious nationalism and give further legitimation to patterns of minority exclusion, because this is exclusionary. This is an exclusionary ideology. In offering these revaluations and alternative narration, I've tried to look at law's role in sustaining, reshaping, and advancing social strife by shining a light on some of the polarizing mechanisms of the law. As we see in India, the language and opinions of the court's decisions cannot be fixed within a liberal politics. They can also be used as political slogans to justify exclusionary politics. To see law's polarizing potential is not to dismiss law out of hand. In pointing to these dynamics, I hope to encourage scholars and policymakers to take seriously both the benefits and the unintended consequences of judicializing disputes over religion, and in doing so to encourage a new spirit of creativity, modesty, and humility about the ameliorative powers of the law. So law is just not always about moderating. It's important to sort of see how it plays out in sort of polarizing and deepening the rifts, and in the way in which the law is both interpreted and how the interpretation is used in the political and the social arena. My end. Thank you.
Thank you so much.